how has ESG permeate the sphere of investment protection and investment disputes in the energy and construction sectors? And are there some lessons to be learned from the past disputes about the risks in this area?
Thank you, Armela. So my answer will be based on three elements, but as an introduction first, I want to say that we can say that there is an exponential increase in investment cases during the last 20 years. This is known. And some of those cases, and most of them, has raised issues concerning a state's ability to regulate in its own sovereign scope, particularly in area touching environment and social policy. This is not new. All the investment cases that started in the beginning of the century, for example, they had most of them this aspect, because the defense of the state was, we decided this, we deny the license based on policy order and generally linked to environment or social policy. It worked or it did not work, this is not the question, it is just an observation. The second one is, if we combine this with the awareness of climate change and the pressure on states to adopt ESG laws now for some since few years, and this is to help to mitigate the climate change and uphold human rights and ensuring good governance. So then we can just conclude that we will have more cases in investment arbitration, or we just can observe that in the last 10 years we got more and more cases involving this question of ESG, or meaning environment and social and governance. So it is true that this awareness of climate change and the pushing of a lot of NGOs and for the inclusion and for the adoption and to regulate the environment and the social question in every state will have an impact on investment arbitration for sure, and investors' claims. And in particular, when it is related to energy and construction, because obviously energy and constructions are sectors which are really governed by tougher environmental regulations with the increase of this awareness of climate change. So we have, as you described, Florian, with the examples with what is happening with the corporates, with the companies, and the fact that they have to be very transparent on standard with the application, their compliance with different standards regarding ESG. This is also going to be compliance with the state law, with the domestic law, because those standards of ESG are now incorporated in different laws, and we have a lot of, in a number of states, we are adopting domestic law with ESG concerns. So if you have in the domestic law ESG concerns and ESG obligations toward the investors and the different companies, but also the states and the organs of the state, those who are giving and allowing license to intervene in energy or to give mine license, for example, and also in construction. So then you have the potential, potential cases between those investors and the host states. So in my view, ESG permeate investment arbitrations in three different ways, and I will address them successively. So the first one will be how ESG is addressed as a ground for claims, on the one hand, and as a defense, on the other hand, from the host state. So this is in the dispute, in investment arbitration in general. But it has also an impact on two other aspects. First, in the drafting of treaties and the drafting of model BITs. So it is a consequence of it. We have a shift in the drafting of model BITs and BITs in the last years based on this awareness of climate change and the need to include ESG provisions. And we will discuss why it is important to do it, to include it, and in which way we can include it in BITs. And the last one, and it will be very short, it is quite quite interesting to see that ESG was also addressed in the debates that are already in course at the UNCITRAL Working Group 3, which is only discussing procedural issues. So it's only procedural. But at the same time, the question of ESG appeared at some point in the debate with the intervention of some NGOs and the calls of some practitioners. So I will first start with ESG in investment arbitration. So in this area, ESG may appear at different time, as I said. First, for the investor claims, and secondly, as a defense from the state. So it is not something new. I mean, we have a lot of cases in the past where the investors went to arbitration and claiming unlawful expropriation, violation of national treatment, minimum standard of treatment, legitimate expectation with respect to a fair and equitable treatment standard. And all of those were based on the fact that the state adopted a conduct which allegedly was grounded on environment policy or interest, but at the end was the basis of an unlawful expropriation, or can be demonstrated as being discriminating to that investor. So the question of environment was already discussed in investment arbitration. What is new and linked to energy in particular is that with the climate change awareness and the change in legislation in some part of the world, and here I will focus, for example, in Europe, in Spain and Italy and also France recently, we reached an arbitral tribunal we are constituted to address cases against France, Spain, Germany, for example, the Czech Republic, and all of those were based on a change in the legislation with respect to energy. So we have those solar cases against Spain, for example. And in those cases, generally what was the base and the ground of the violation was the violation of fair and equitable treatment, and in particular legitimate expectations of the investor, which were frustrated after they have started investing in the country, and we had a change in the legislation with respect to energy and the obligation of the investors, for example. And based on this, the arbitral tribunal had to analyze whether there was a breach of the legitimate expectation, whether the state failed to provide a stable and predictable legal framework for those investors, whether the state was transparent. So you see that the beginning is the violation of a standard, the fair and equitable treatment, but at the same time, and then we look and we go through the different conduct that a state can adopt, and we have sub-obligation in a way, for example, when we go to transparency, and whether the state has acted also in an arbitrary and discriminatory way, and also whether that legislation or that was disproportionate based on the investment that was made by the investor. So we have more and more cases where the question of ESG is raised by the investor, and it is the basis of the claim. On the other hand, we have in our investment arbitration more defense based of the host state based on ESG concern. First, and here I'm going to just give a list and go quite quickly on those. First, the host state can use as a defense in the jurisdiction and admissibility phase based on ESG, saying, for example, the investment that you made is unlawful because it was established and created in breach of the host state's environmental law, and for this it could be denied the protection at this first step, or also admissibility. And this can work obviously, if you have domestic law, including ESG, including specific provision with respect to environment and social and governance, if you don't have them, so I mean the investment is in compliance with the domestic law, if there is no obligation to respect those standards and those provisions. And those were used also in particular for corruption. So we have a lot of cases like the Union Fenosa against Egypt, for example. I was in the team defending Egypt at the time, and we have worked a lot. And I can tell you, really strong evidence again showing that there was a corruption scheme, and we were not followed by the tribunal. And as you said, it was totally obvious, but at the same time, the domestic law of Egypt was not very clear on the anti-bribery system, and the signature of different contracts seemed to be totally lawful to the tribunal. So,
sorry for interrupting, but I have just one question. Couldn't you engage the expert witness for the signature?
For the signature?
For the signature of the contract.
I mean, when it touches to the host state, it is difficult to invite as witness the officials who may have signed something. This is for, but it wasn't this. Okay. The issue wasn't with the official here. Okay. But we are talking about a contract that was signed 10 years before, and some of the persons involved were not were not in Egypt and were not in Spain anymore, and we could not call them as witness because they are not part of the arbitration, so we cannot oblige people to come and witness. So based on the document they signed, the contract, we had copies of the contract, and the scheme of the contract, it was evident that something was wrong. We got it was obvious that something was wrong in the contract, but if you don't have the witnesses, as you said, the people who signed to testify, and in a way they're not going to sign and say, yes, I agree to this contract of agency, to help with the signature of this big contract with the state, because this is criminal, for example, for them. So they cannot, for this you cannot have witnesses at all. But just to go back to an investment arbitration, so this is a solid defense for states, but it is difficult sometimes to prove it. But on the other hand, we have arbitral tribunals who obviously obviously had rejected their own jurisdiction based on this ground. The same with the compliance with domestic law. An investment to be protected by a BIT should be established in accordance with the domestic law. Obviously, this will depend on the provision of the treaty and how it is drafted, and sometimes we don't have the in accordance with domestic law. But even in those cases, some arbitral tribunals interpreted the treaties in a way and where they rejected jurisdiction because they considered that the investment was established in contradiction and with the domestic law. And finally, with respect to environment, I can quote a case, the Court of Mining against Kenya, for example, where here, in particular, we had the arbitral tribunal decided not to recognize themselves as having jurisdiction because the investor didn't comply with the environmental law of the state when they got the license. And here again, they tried in 2007 to get the license. They took a long time to get a license, 6 or 7 years later. And that license was revoked 6 months after because of a change in the government, a change in the awareness of the environmental issues. And here again, the tribunal was able to decide that they don't have jurisdiction because it was contradictory to the law, even if, they got the license and it was revoked 6 months later. In a way, we can say that the state has changed its law, but no, the law didn't change. It is just the interpretation of that law, and the tribunal went through the interpretation and decided that in one way that it wasn't in compliance with the domestic law. Another way to make a defense for a host state is also to include counterclaims, to raise counterclaims against the investors based on investment and social and governance grounds. And here again, those counterclaims, we have two issues. First, whether in the BIT we have this possibility for the host state to raise counterclaims or not. And also, if you want to raise counterclaims, you need to have obligations in the treaty. You need to have a ground, even if you are the host states, not only domestic law, but also, why not, in the treaty. And with this, and the last element in the defense will be also the reduction of investor damages grounded on contributory fault or grounded on the idea that, okay, there is the state has violated the treaty, but you contributed in a way to your damages by violating environmental and human rights law. And here we reach a point today where the trend is to add in the treaties the possibility to make counterclaims for a host state, and also to add provisions with obligation for the investors with respect to environment and social and governance. And then adding provisions in the treaty where we are inviting, in case of a dispute, the arbitral tribunal will have to look and assess whether the investor's non-compliance with environmental or human rights law of the state will diminish his part of damages, and this trend is mirrored today, I think, in the Dutch model BIT and the India model BIT, for example. So with this, I'm reaching the last point, and I'm not going to be the second point, but I won't be long on the third one, is ESG in BIT. So with this, you understand that the consequence of the impact of ESG in investment arbitration is reflected also in the drafting of treaties, and the new model BITs, the new BITs that are now enacted around the world, generally include obligation for investors with respect to environment, social governance, but also limitation for damages and limitation for access to ISDS if you have violated domestic law. So if you have a strong domestic law, including ESG provisions that are not followed by the investors, so then you can cut the road to the investors to go to arbitration. And and the last thing is that in the ESG came in the debate in ISDS reform at the working group. And here, the only thing that I want to say is that at two occasions, the question was raised by NGO. One NGO, for instance, it was Client Earth, who submitted a report proposing first carving out all governmental measures taken in pursuit of international obligation under the Paris Agreement on Climate Change from challenge through investor-state dispute resolution, meaning every measure taken by a state in application of the Paris Agreement on Climate Change, for example, should be outside the scope of any investment dispute resolution in BIT, but also allowing counterclaims by and ensuring full participation of the affected third parties, particularly in relation to the environmental impact, meaning calling for the participation of NGOs in investment arbitration when it touches to environment, social, and governance. The second one was not linked to the Group 3, but at the OECD, where we have one of our colleagues, George Kahale, who is a partner in one of law firms and who was involved in multiple cases as representative of states, who called for a declaration of states states declaration or interpretation, common interpretation, explaining that, saying that it is understood and agreed that measures taken by states to mitigate the effects of climate change do not constitute expropriation or a violation of the fair and equitable treatment standard incorporated in investment treaties. So a call of a sort of a general declaration of states to of treaties. And we know that, for example, that the common interpretation of a provision of treaties can have an impact in investment arbitration, because the arbitral tribunal can be linked and bound by that interpretation by the states, because the ground of investment arbitration is a bilateral investment treaty or multilateral or regional treaty, for example. And with this overview of what we have in investment arbitration, I will just conclude that we can also add those in investment contracts. It's not only in treaties, but also we can do this in changing the provisions in investment contracts, adding standards as we do in commercial arbitration, I mean in contracts with construction and energy contracts. And with this, I would say thank you for being that long. Thank you.